Conversations. I am your host, Alex Limontes. I want to thank everyone for your continued support, and I want to thank our primary sponsor, Hearst Limontes, an Indiana law firm with over 50 years of experience helping injured Hoosiers and their families. I am here today with a dynamic duo of badass female trial lawyers. Um, Amy Davis from, it says Amy David. Oh my God. Amy Davis from the law office of Amy Davis and Catherine Karras from Hearst Limontes.
I was hoping you would call us a dynamic duo.
Yes, badass. So
I'm actually
trailblazer.
speaking at a convention called Embrace Your Inner Badass next month.
That's awesome.
Love it.
Yeah. So this episode is a very special episode because it's part of our litigation lessons series where we dive deep into the stories that shape our jury trials and our jury system here in Indiana by talking about recent cases that we've litigated or that others have litigated and tried here and across Indiana. The last litigation lesson episode was attorney Chase Wilson and I, who tried a case in Marion County Superior Court. And in this episode, we're going to talk with Amy and Katie about a medical malpractice case that they tried in Marion County Superior Court last year that resulted in a great verdict for our client. Thank you, Amy and Katie, for joining us.
Thanks for having us.
Thank you.
So let's start. You know, you guys have both been on the show. We've kind of talked a little bit about your backgrounds, and so we don't have to kind of go into a lot of those details, but I want you to think about your backgrounds, where you came from, in particular, when it comes to medical malpractice cases, because handling a med mal case is very tough and very different from a traditional PI case. So when you think about kind of your path that you took to get here, what and we can start with you, Amy. What are some of the things that led you to pursue to start working on med mal cases in particular?
Wasn't on purpose. Same. However, my grandfather died as a result of medical malpractice when I was around 12 years old. So I had experience personally with that kind of a claim. And then as I moved on in my legal career, and it was actually right after I had opened up my own firm, Lori Brown put me in contact with George Gray because George was just looking for somebody to help at their office get things ready for trial. So I had the fortune of being allowed to be trained by George Gray, who was, the guy for nursing home cases in this state. So that was just an incredible experience, just getting to learn from him about nursing home cases particularly. And that's sort of how I got into doing any medical malpractice, is through those nursing home cases.
And Katie, you took a little different road. You did med mal defense.
Defense work.
Yeah.
Yeah, for the first 4 years out of law school, I did medical malpractice defense work. And while I really enjoyed diving into the medical side of things, I realized as time went on that working for insurance companies, because your clients are the doctors, but you report to the insurance companies.
Yeah.
That's who is the decision maker in the case. I really felt like my heart was with the plaintiff side, and with George Gray retiring and Amy taking over some of his cases and our office taking over some of his cases, that led me to get back into doing the medical malpractice and being able to do it on the plaintiff side, since that's where I've been working for almost 14 years now.
And I had Tina Bell on the show, and she was talking about, she did med mal defense for a long time.
She did. She
Yeah.
did. We when I was a defense lawyer, when she was a defense lawyer, and I was a defense lawyer when she made the switch,
Yeah.
and she was a force when she made the switch from day one.
Yeah.
She was an absolute force, and we knew that if we saw Tina on the other side of things, she was moving it quick and swift, and there was like no holds bar with Tina. And I love that she still has that same, I feel like, I mean, I don't see her on the other side anymore. Obviously, I see her on this side, but I know that she has that same enthusiasm and same reputation all these years later, that she still moves cases very, very swiftly, and she's very aggressive, which is why she has such success.
The one of the things that she said that I thought was so interesting, I never thought about it this way, was she thought she was this badass defense attorney, but when she started doing the plaintiff side, realized how much more difficult it was, and then ultimately realized that when you walk into a courtroom with a doctor on your arm, you've got such a leg up. And I never realized, never
Abs-
thought of it that way.
oh,
Mhm.
Yeah.
absolutely true.
It's like starting with a win.
It really is. It's just something about the reputation or respect that doctors are given in the state of Indiana, that really ultimately starts with the protections that they were given with the enactment of our Medical Malpractice Act back in the 1970s. And that protection has only just grown really for the doctors, and for our all of the healthcare providers, not just doctors. It extends to, our facilities as well. And Indiana really, really protects its doctors, I think, just for fear that we'll lose them
Yeah.
if we don't protect them. And so a lot of negligence is swept under the rug. And that's kind of how this case started that we're going to talk about.
Yeah. And so before before we talk about that case, I get a lot of, you guys do both standard, I'll call it traditional negligence cases, even though some of these could be negligence cases too if they're not qualified,
Right.
Correct.
right? So you do those, well, we'll just say car crash case or trip and fall, versus this type of a case. Amy, what are some of the biggest differences between a medical malpractice case and a just traditional negligence case?
I think the biggest difference is you can't take anything that has a question mark. So you have to have ironclad almost negligence. Um, I wouldn't say almost, it has to be
Mhm.
because we're still losing, I think, 80% of panels on cases that we consider to be ironclad because
Mhm.
we can't take anything else.
Mhm.
Right.
Mhm.
So that's the biggest difference. The second biggest difference is they are very expensive. You can almost guarantee that you will
How
have
expensive.
right? He's paying the bills, right? You can almost guarantee that you will have to hire an expert, and the ones involved in medical malpractice, you have to they cost a lot, and you have to most of the time hire somebody from out of state, because they're gonna be looking at Indiana doctors because that's who we have to sue. The other big difference is you have to have huge damages.
Mhm.
There are ironclad negligence cases in medical malpractice that we turn down routinely because the damages don't meet a threshold that would allow us to be working on a case for 5 to 8 years
Yeah.
and still be able to make it be profitable because at the end of the day, we have to still be in business when this is all over. And as running a solo practice, doing any med mal is the scariest thing in the world for me because you could spend $100,000 on a case. The defense walks in with a good looking doctor and you're done before you start.
Yeah.
So, especially if at some point they say, "Oh, we're sorry this happened," that's okay. Well, the doctor's sorry anyway. So,
Right.
Don't
um,
want to ruin his chance to
right.
practice in the future.
Even though that rarely happens also. And then, aside from those things, you can't go straight to filing a lawsuit if the provider is what is called a qualified healthcare provider. You have to submit to a panel process. So your complaint has to be filed with the Department of Insurance, and then you get what's supposed to be a three-person impartial panel, but they are all physicians or providers who pay into the same patient's compensation fund that, ultimately if you pick the right case, the money's going to be coming from.
Right.
And these are their colleagues in addition to that. So,
And people who could be reviewing care that they provide later if
right.
they are ever.
And what we find too,
It's just if they're of the same practice area, each practice area is probably a small network. So they're all essentially reviewing their own colleague. So if they're ever put where they have a claim against them, the same type of people or potentially the same people could be the ones reviewing their care. So it's just kind of like what goes around comes around. That's how I kind of feel about it. Or sometimes people do say it's what the fox guarding the hen house or whatever. I mean, I've heard that be described because it's basically your colleagues are reviewing your care and they're more likely to give the doctor or the healthcare provider the benefit of the doubt because they would want it too if they made
right.
if they made a negligent decision.
Because I mean, at the end of the day, what we know is, and I think Katie and I would both agree, we don't want to sue doctors who don't do something wrong, that who haven't done something wrong.
Correct.
We want to make sure we have the right people um, that did do the negligence. But at the same time, I mean, we also think about like the people that end up on our panel that do look at these things, and because I think a lot of them don't really want really bad doctors here either. It's just such a hard line for them to walk, knowing that they could see that person at the next job they have. And what we found a lot in nursing home cases in particular is we have so many people conflict out because as the nursing home industry in Indiana gets to be more county-owned hospitals that own most of the places, there's so much overlap from these providers. They've all sort of worked in the same field, and I'm
Yeah.
conflicted how many people out
So
in this
many.
case even.
Well, ultimately, a lot of people don't know most of your nursing homes in the state of Indiana are owned and run by a handful of the county-owned hospitals in our state.
So
So Johnson,
Johnson County could own in Randolph County.
correct, Johnson Memorial Hospital, Hendricks Regional Health, Hancock, they own a lot of the nursing homes.
Right.
And so if you have a nurse that works in another one of those facilities owned by Johnson Memorial Hospital, they then can't review the care that's given by you know, a nursing home that's also owned by that same hospital. So there are a lot of conflicts. It is difficult, and the reality is, if it's if the panel is looking at care, and if they are to give a benefit of the doubt, it always goes to the physician or the healthcare provider. I mean, it never goes to the plaintiff. That's why 70 or 80% of panel opinions are in favor of the defendants, even on cases that we all vet before we ever file them. So, and Amy hit the nail on the head that you have to feel really, really confident on the liability, and the damages have to be high, not just for us to remain in business and make it a good business decision. But I have this conversation with clients. Like, if you don't have severe and permanent damages, or if you haven't lost a loved one from this negligence, how is it fair for me to sign this as a case and have you come along for 4, 5, 6 years, and I spend this many, many thousands in costs to get a small settlement that wasn't worth your time either. You have to participate in this lawsuit, but if there's no real recovery that's going to be had for you, was it worthwhile for me to put you through that? And because, whether it's litigation or in the panel process, it still goes to the discovery phase. It still is a lot on that family, or on that person who was injured. So if the damages aren't severe and permanent, like, it's not really worthwhile for their time either. And if they're wanting basically the doctor to be reported, there's other reporting ways rather than the litigation process. So you can report them to the state if you feel that there are, issues with regard to treatment that don't necessarily involve litigation or monetary damages that you're trying to recover.
And what's hard about that timeline too is, I mean, it's not just long and you're part of it, but you can't move on from the thing that happened to you either.
Stuck.
It's always there.
Yeah.
And in the case that Katie and I are going to talk about today, the we originally we represented the wife of Mr. Brower, and she was never able to see accountability for what happened to her husband because this process takes so long. She died before
Mhm.
she could ever see justice done in this case.
Yeah, I mean, we didn't get the ultimate final order on this case until 8 years after his passing, and she only lived 3.5 years after his passing. You would think 3.5 years would be enough to see the justice, but, I mean, it took a solid 8 years because I always explain to clients and to people that don't know anything about medical malpractice is that, if you have like a traditional negligence case, it's, you go to trial and you have one case. In medical malpractice, it's three. You have panel, which is its own whole, like to a literal trial to healthcare providers. And then you have your trial litigation case against those healthcare providers that you can file after you get the panel opinion, whether it was positive for you or not. Then you have to file an actual trial court, and then once they settle, they're capped at how much they have to pay their insurance company, and then you have to have another third trial against the state fund for the excess. And so that's what I mean. That's why it takes so long because there's literally three trials to ever get to the full recovery.
And each time, in almost all the cases I've had, and each time, you could have different lawyers for each phase
Yeah.
too.
Mhm.
So, it's like starting over each time. You hope that they've transmitted information to the next
Mhm.
people, but a lot of the time it is just here we go again.
And
Well, it's to their
definitely
benefit to play dumb like that.
Right.
because it extends it.
Yeah.
I need time to get up to
Yeah.
speed. Definitely
But
between the first two stages, sometimes the same lawyers, but I mean, it takes so long. There is
yeah.
turnover at these law firms, and then definitely the last stage against the state fund. It's always someone. I mean, it's always
It's
a
an
new.
AG, right?
Well, yeah, it's just someone who works. Well, it's not always.
Private counsel.
It is.
It's often like one of the people that works in the fund, or it is they hire someone out. It depends on how busy the fund is at the time, what cases they will take, and what cases they refer out. So, we're seeing I think we're seeing some new faces too.
Yeah, I mean, they're all familiar with the medical malpractice process, but it's never the same attorney that was on it before.
Well, it's like you said. I mean, you're starting the litigation process all over again,
Mhm.
3 times.
3 times,
You
yeah.
know,
And
so
and if it's someone who's passed, the families don't understand why this keeps happening. It's very difficult to explain to people why it's taking so long, why we have to keep starting over when their loved one or they themselves were the victim of the thing.
Yeah.
yeah,
The question I often get is why is it that the physician gets all the benefit of the system and the victim is the one that is jumping through all the hoops? And I think it's really hard for us to explain. Um, and it's hard to explain, particularly if you have a case that's gonna be going to the fund, why a physician is allowed to even pay less than the cap too. So, Indiana has in their statute that to be able to advance a medical malpractice case to the patient's compensation fund,
Stage 3.
stage 3, you can do it in a variety of payment options, one lump sum, or you can do it in with annuities.
yeah,
Well, if that option is given, that's usually the highest offer we get, right? So we have to make a decision. Do we want to go to trial on this, or do we want to depending on what the cap is at the time, because it's on a sliding scale now. Do we want to take if it's a 1.65 cap, we'll say, then the doctor's liability is limited to 400,000.
yeah.
They can issue an annuity for $300,001.
Their carrier, their
Their
insurance
carrier.
carrier.
Yeah. Because it's not them either. So, right, you're never really holding the person accountable that did the thing. And as Katie mentioned earlier, the idea we think behind it was to keep doctors in the state. But, what and don't have like a generalization again. I don't have a bias against all doctors, but I do think that what it's led to is that Indiana definitely has more bad doctors in this state because there really isn't real accountability for them should they have a mistake.
Right.
Because other states don't have these protections or limitations.
And they don't
Florida's got a
always
250 cap, is what I heard.
that's I think that just
They changed it.
recently had a some sort of amendment.
Okay.
But but yeah, I mean, there are a lot of states, but I think their cap is only on non-economics.
Okay.
So Indiana has a cap that covers both economic and non-economic damages. So you could have, say, a baby has a birth injury,
Yeah.
and their life care plan is going to be $15 million. The cap is still 1.85 if it happens tomorrow, right?
Yeah.
It doesn't provide for the care they're going to need along their lifetime, which is so it's very frustrating on our side because we can't ever get a full recovery for them, one. And the second thing it does is it shifts the burden of the cost of their care to the state and the taxpayers because those kids are now going to have to be on Medicaid waiver their entire
Yeah.
almost their entire life
Yeah.
once the money runs out.
Yeah.
And I think Tina went through like the history of the Medical Malpractice Act, explaining, why we had it, and because our governor was
A
was a
doctor.
doctor. And so I mean, but obviously that was like in the 70s before any of us were born. So,
Right.
and definitely before any of us were practicing. So we just tried to play, deal with the cards that we were,
Yeah.
Yep.
deal with that and that we were given, and do our very best. But in the end, it's a hard conversation that we have to have with prospective clients and with current clients. I have to have hard conversations with ongoing clients about why the process doesn't move faster, because the for part one is all administrative. And so there's really not a lot of teeth to move it forward faster, even if I wish.
Right.
And so I mean, you can't get the court involved, but that usually involves initial delays too. And then you have to have the tough conversations about when it's time to settle. Oh, by the way, you don't actually get that full cap because the insurance carrier for the doctor or the nursing home, they can pay you $100,000 less and put it into annuity, and your grandchildren will see that money because you have to put it in annuity for 50 years for it to gain 100,000. But somebody will see that money. But if you don't do that, then you won't see any of the other money from part three. And it's you have these conversations with people, and they're like, oh my gosh. I I try, now that I'm signing cases new, I try to have those conversations early on
So they expect.
so they understand. There's reminders that have to come out because
Right.
people, they hear it, it's overwhelming and
It
information,
is.
and then you have to tell it again.
And it's complicated and doesn't make sense, right? I think if something
Yeah.
is complicated and you kind of can understand it, then it's easier to accept. But
Hmm.
then when it's complex, it doesn't benefit the person who gets hurt,
Yeah.
and it it doesn't in any way make up for what happened. It feels very unfair, and then we just hope that we can say to them, like, yes, that's why we take very few of these, right?
Right.
And that's why, we have to be really selective, and we're doing everything we can to get as much as we can for you and write your legislator.
Right.
Yeah,
Right.
I have had that conversation. Also, let's not even get into the Adult Wrongful Death Act that
Yeah.
limits recovery even further if you're an adult that dies without um any dependents, which I will tell you, in when we do the nursing home work, I mean, primarily, not always, but primarily our potential clients are older women who have no spouse, are widowed, or do not have a spouse. And obviously, if you're an older woman that's single, you're not going to have any dependent children either. Their children are generally in their 40s and 50s, and or men, but it's mostly, most of our claims are women. But you basically, you're going to have, if you're living in a nursing home, you're most likely do not have a spouse. Not always, but I would say at least 80%
It's definitely the majority.
of my nursing home
Yeah.
clients are single, women with no dependents. And so, our Indiana law does limit adult wrongful death to 300,000 plus the other attorney fees, expenses, burial expenses, things like that. But I mean, that limits your recovery too. And so to have all these conversations that you might wait 5 to 8 years to get a recovery that's capped at, you know 450 or 500,000 maybe, and that's really hard for this family to hear.
Especially when, like, the consequences that their loved one died.
Yeah.
Mhm.
Um, Katie and I actually were talking about this the other day with cases where someone may have suffered from a bed sore, and how the way that we value these things is how long the sore lasted, right? And
Mhm.
how long the person suffered from it. But if they die from it, it's actually worse for the person we're trying to get recovery for,
Yeah.
because then they
Mhm.
fall under the absolute cap of the Adult Wrongful Death Act.
Right.
And when we were negotiating these things, they never start at, "Oh, yeah, we definitely think this is, like, a case where you should get all of that," right? But
Right. They
if
never
it's
offer you the full three.
no,
Or
if
No.
it's the cap, that's the ceiling, and they go down from
yeah,
there.
they
Yeah,
go. That's where
exactly.
they're.
It's their
Yeah.
policy limit, if you will. And then you also have to have another. This podcast is just turning into hard conversations you have to have with clients,
Right.
medical malpractice. Because the other hard conversation you have is when you have an adult wrongful death case like that, or potentially a survivorship, what you call is for the pain and suffering. You have to have a conversation with the family. It's like, okay, well, are you is it for your loss and love and companionship of your mother or your father or your sibling? Is it your loss for them dying sooner than they should have? Or is it their pain and suffering they experienced from the time of the malpractice to the time of the death? Because you can't talk about both.
You can't.
You can only talk about one. And so you also have to pick, in the end, you have to pick, what are you going to talk about? Because if you can't say that my mom suffered with this bed sore for 6 weeks and then she ended up dying from it, from an infection from the bed sore, and I've lost her, and now my life is sad because I lost my mom many years before she should have passed away. You can only talk about one or the other. It's like sometimes I'm like, oh my god.
And heaven forbid you have someone that had a bed sore for a long time but didn't complain about it, right? Then how do you prove the suffering? It's just very it's a very complicated. I mean, we show pictures, right? Because
Yeah.
again, and we can't take but the worst things out there,
Bad
because it just
pictures. I've seen some of them.
yeah.
Horrible.
Well, I
I have
remember
a visceral reaction sometimes to them. I cannot even handle it.
I remember Ashley Hadler had gone to the legislature to talk about, it was when they were passing the COVID immunity bill stuff. And she was showing the legislature, or whatever committee she was in front of, the pictures that we had. And one of I think it was the committee chair at the time, was like, "Well, you guys are all coming, you'll come here and show us the worst pictures that you have. And that's all we get to see here." I'm shouting at
That was Jerry Torp.
it wasn't, it was a woman. I was,
Retired.
I'm like back in my watching this, I'm just like screaming at the thing, like, "Those are the only pictures. Those are the only cases we can take because of you."
Yeah. Yeah.
Yeah, but I mean, even if that's the worst of the worst, it still happened.
Yeah.
Yes.
It still happened,
But
and it keeps happening.
right.
It does.
I mean, the amount, I know I'm certain for you too, the amount of phone calls I get on a daily basis for medical malpractice and nursing home neglect cases is astounding, and they all sound very sad. And I mean, we have to investigate them,
Yeah.
and a lot of times that there is neglect there, but it's like there's a question. You can see, like, okay, I think there's neglect. That really seems like there was a problem. But if there's any question, any potential issue of fact, any potential defense that we see from the beginning, we can't sign it.
Yeah.
Even if we feel pretty high about the fact that there was malpractice, if we feel like there could ever be a defense, if we can anticipate a defense, we can't sign it. Sad.
So let's talk a little bit about this case. Okay. Amy, tell me a little bit about the clients. What happened?
So our client is Jim Brower. He is 82 years old at the time that this happens, and he was having some like vascular issues. And so he needed to have surgery. And so they got him all set up for surgery. He has a successful surgery. He goes into the nursing home, which we pursued for but I say nursing home. We did not say nursing home before. Long-term care facility for rehabilitation stay.
Post-operative rehabilitation, just for care after
Right.
a temporary care.
Rehab.
Yeah,
Yes,
rehab,
rehab.
just for rehab.
So they
Surgery rehab, not actual
Right.
rehab.
and so he has to have two of these surgeries, one on one side, one on the other. So he goes to this long-term care facility for his rehab. And then while he's there, they get him all set up and recovered enough to do the second surgery. He has a second successful surgery, and then he comes back to the same place to do another rehab stay. And what happens between the first and the second one is, he has an autoimmune disorder for that he takes met, um, this medication called methotrexate. And methotrexate is a medication that can be very harmful if administered inappropriately. So it is to keep autoimmune symptoms at bay. You take like 6 pills on a Monday, and then over the course of the week, it distributes it to kind of keep your symptoms
Yeah.
lower. So, but it's a medication that you have to take just once a week. If you take it on a daily basis, it kills you because it becomes toxic to your body. So,
And that's how it's given. A high
right,
dose, it takes care of the symptoms. I think he had like some sort of arthritis. Takes
rheumatoid
yeah,
arthritis is what it
takes
was.
yeah, takes the deals with the symptoms, and then it dissipates, and then, it works its magic, and then the next week it's out of the body, you take it again.
And mind you, during his first rehabilitation stay, this facility administered the medication properly. So they knew how he should have been dosed,
Yeah.
because they did it correctly during the first rehabilitation stay.
It's also a very commonly prescribed medication for arthritis, and a lot of people who are in these types of facilities have arthritis because they're older. So it's nothing that anybody in a long-term care place or a rehabilitation facility would that they've never seen it
Right.
before.
It's pretty normal for them.
Yeah, it should be.
Yes.
I mean, for honestly, for
Right.
anybody with any sort of medical background should be familiar with it.
But it also is a medication that comes with like a black box label.
Oh,
So they're on alert. The nurses and anyone providing care is on alert that this could be dangerous if it was used improperly.
Yeah.
So what happens when Mr. Brower goes back to his rehab is that the medication gets written down wrong on the script, and they
it was written down wrong initially on his discharge summary paperwork, which then the doctor
it was a nurse.
then the nurse looked at that from the rehab facility, put it on an order, and the doctor signed it. So they basically just took this discharge summary like it was truth.
But that was not a
but
prescribing
but it
doctor,
wasn't.
right?
It
So
was just summary.
it was just a discharge summary. It's not someone actually giving
Yeah.
directions to write it that way. It's just like he's taking this.
From the discharge.
And
Yeah.
again, this is a facility that knew the way that it should be dosed because they were giving it to him correctly just, I don't, what, 4 days before
Yeah,
that?
he had not been gone very long. They should have just looked back at their own medical records and their own medication administration records as to how they were dosing it and giving it just the
Yeah.
prior week.
So instead of 6 pills on a Monday, they were dosing twice daily, which turns out will kill you really fast. In our case, 7 days later. So, and there were many different warnings, um, and warning signs and symptoms. The first being, so what happened, once the nursing staff created the script, they sent it to the doctor who we were told was on vacation at the time. And the doctor just batch signing these prescriptions that were sent to him by the nursing home.
Just essentially signing without looking.
Right. And during his deposition later on, he said that if he had looked at the prescription, he would have immediately realized that it was a lethal dosing
Yeah.
of methotrexate. Um, but he didn't look at it.
Right.
So, and then the next, so in our case, we had like 3 target defendants.
Mhm.
The first was the doctor for signing a script that he didn't know what it was, and in fact, if he had looked at it, would have realized was lethal. The second one was the pharmacy, and this is why. So the pharmacy gets the prescription. Someone within the pharmacy realizes that this is an improper dose, and so that person calls the nursing home and says, "This is an improper dose." And then they say, "This is improper. You need to put that into your medication administration record."
this is how you're really supposed
Yeah.
to dose it.
Right.
But that was not actually the protocol.
No.
For if you have an improper dose, you're supposed to refuse the order and require a new order be sent.
Yes.
Because there's no way for
Pharmacy.
the pharmacy to ensure that the nursing home's medication administration record is corrected. The phone call or note or whatever they sent over clearly wasn't enough. So they should have required a new order be issued, signed, and sent over so that that new order is what was
Yeah.
filled. But instead, they filled it with the instruction, you don't dose it like you've requested.
They violated their own policy.
Right.
Correct.
Well, and you can see from when we look back at the records finally,
Yeah.
when we got them, you can see that the pharmacy notes that they called, they remember like the first name of a person they talked to at the
Mhm.
long-term care facility, but there is no documentation of that call at the long-term care facility at all. And in fact, unless there is a new script written, it doesn't make it into the medication administration record. The script they wrote is the only thing that will be in the medication administration record unless the new script is written.
Wow.
So then
That's
what
why these policies and procedures are in
matter?
place.
They're really important, especially when you have tricky. It's not even tricky. They know what this drug does.
Yeah.
Um,
Well, it's just people who are unfortunately overworked, underpaid, have a lot of patients, and they're just not paying attention to the actual effects of every little thing. That's why these fail stops are in place to do the thinking for you essentially. If
Yeah.
and they all bypass the policies that were set in place to protect this person.
Wow.
Including I guess the last bit of it is that Mr. Brower started experiencing symptoms of an overdose pretty quickly. And then when the doctor who batch signed or signed without looking the order when he came in to evaluate him, because he had never actually looked at the order, he didn't realize what he was taking and obviously didn't realize that he was being overdosed, actively overdosed. So he didn't even put it together that what the patient was experiencing were signs and symptoms of an overdose because in his mind he didn't even realize that he had signed that order for it. And so he had all these other um diagnoses in his differential as to what was causing all this, and that's what he's telling the family. All the while, the nurses, who are on the other hand, are still just like giving him this medication,
twice a day.
overdosing over and over and over again.
And what happens when you have toxicity is like their sores will open up in your throat. So Mr. Brower is complaining of like the worst sore throat he's ever had in his life, and this is a telltale sign. So what happens next, and this is probably what ended up being like the thing that really helped us get our case resolved,
Mhm.
is that because they're dosing it and giving so many pills incorrectly, they run out of the medication. And so they call the pharmacy for more, and the pharmacy is like, you should not be out of this.
Yeah.
So then
Remember our conversation last week?
right. And then
Once a week.
but still at that time, now someone at the long-term care facility knows, okay, we messed up. They're not going to fill this medication now because we shouldn't be out of it. But they don't tell the doctor and they don't tell the family
Oh no.
that this is and there are things you can do to reverse the overdose. They did
He
none
could
of
have
them.
potentially been saved. I mean, we'll never
We don't
know,
know.
but this was like 2 or 3 days before his death. They could have ordered the reversal, and they didn't because they didn't know. The doctor didn't know. And so the nurses knew they had messed up. The pharmacy had told them again, like, you obviously gave this when you shouldn't have, but the doctor didn't know, and then the family didn't know. So the family is losing their loved one with no idea why, and then did lose him,
Yeah.
no idea why. And they're thinking, I mean, they were thinking all different thoughts because
Mhm.
there were some blame shifting from the facility to the family too.
Mean.
It was just
Right.
terrible. And so that's, I think it was so many things, but then that time where the facility knew that they knew 100% they had overdosed and kept it to themselves.
What did the panel do
That was a 3-0 panel.
Yeah, it was
Thankfully,
unanimous malpractice.
shout out to George Gray and his team over there because they got us through the panel. Katie and I took over after panel, right?
Yeah,
So
we were getting we took over when the case was getting close to going to trial. So the panel did unanimously find against all three of the entities we're talking about. I think that there were some
we only
other.
had to be against the doctor, right? Because okay, so here's
Oh
our
yes,
situation was
yes,
this:
yes.
the doctor in this instance was the only qualified healthcare provider.
Correct. Yeah.
So
Weren't qualified.
the others were not qualified. So
Correct.
this is a rare case where you have the mix of them, which
Yeah.
creates its own set of like issues
Because
because
the case against the facility just had to sit and wait.
right.
But they had originally brought claims against some of the treaters at the hospital for how the discharge paperwork looked.
That's the panel went against,
But
right?
the panel found that wasn't malpractice. And so that the only qualified provider that actually committed malpractice was when the doctor signed that order. That if things are made and paperwork is can be an error on the discharge, but there was no actual order from that discharge paperwork. And yes, something was typed in incorrectly, but there's nothing to indicate that that order was given to the patient because of that paperwork, because the doctor made the affirmative action to sign that
Yeah.
the new order at the facility.
Basically, the doctor at the hospital was not a treating physician for the rheumatoid arthritis, wasn't the person that would be writing that anyway. So that person was only really writing information down. The actual care provider was responsible for
Yeah.
putting in the order for the correct medication. So that's what I think when we talked about it earlier, we said like this is why, this this wasn't really pursued. It was pursued initially, but the panel said
Mhm.
no.
Yeah. And so you went to panel, but you had to stay the case against the unqualified
Yeah,
providers.
the pharmacy and the nursing facility.
And then did you have to try the case in stage 2, or did you settle that case and then go to the fund?
We were about 2 or 3 weeks away.
Yeah, we weren't too far away. So we went and settled against the doctor at the mediation for their fund amount, which at that time was 250, was really $187,001 because the case happened so long ago. So that one settled, and then part three was only for that doctor's negligence. And then shortly before trial, after mediation, the case did resolve against the facility and the pharmacy. So then part three only went against interest against the doctor.
Huh.
And then the state, there was a big thing. That's why we ended up trying it, because the state fund felt like the state of Mr. Brower had received enough money based upon the settlement we had received from the facility, and also really tried to shift the responsibility to those providers that were not covered by the fund.
Yeah.
But because of the way our laws are in Indiana, which we didn't talk about, which is claims against qualified providers like doctors, are subject to a different standard of negligence.
Yeah.
It's not comparative fault, like who's more at fault. It's an all or nothing sort of situation. So that was also, you had kind of a mixed liability because you had comparative fault with the nursing facility and pharmacy, and then now there was no contributory negligence against doctor. There was no allegation really in the end that Mr. Brower or his family was negligent. It was more along the law school type arguments that people make in these cases of the mixed responsibility between the defendants. So
Okay.
that's where they got complicated, because you had that concept of joint and several liability, which
Oh, fun.
But it got really frustrating for Katie and I because we, were working really hard to get the best result for this family who, it's been 8 years now, and we're being told by the fund, well, you guys did so well with these underlying providers, these non-qualified providers, that you shouldn't get any more money for what the doctor did. And it was pretty wild for us
it
to even hear that.
it was difficult, because the reality is that we did do well for the family, but the belief from everyone involved was that that was just half of it.
Yeah.
And that the
Everyone
fund.
involved being Katie, me, and our family, right?
Side.
Because
Well, but I feel like the facility,
Sure, the
the
facility and the
facility
pharmacy.
and the pharmacy, they felt like they took half responsibility
Right.
in their value. They knew what the value was, and they took half responsibility, and it all kind of added up to an amount where the other half that was left was
The
the
doctor's
full
responsibility, yes.
fund amount.
Right.
Mhm.
That was what was left.
And
That
that's
was
what
the
we
full
argued.
value of the case, and that's and we um that's why we tried it, because we felt that the full amount was what the family was still entitled to, because we had gotten essentially, the other side of it from the
What did the fund use to base their argument off of? What was their reasoning that you guys have already gotten enough money for this?
So there were multiple things. I want to back up for a minute because, when we talked about how we wanted to get this case done, I mean, it was complicated for Katie and I too because we thought that it didn't really go the way that we thought. We thought that the fund would accept their part of the responsibility, and so it was frustrating to get ready, but also, this whole time, we're hearing from outside sources all over the place, like, maybe you don't want to try this because he was so old when this happened.
yeah, I mean, the fund's argument essentially was life expectancy.
Yeah.
Life expectancy of him, life expectancy of the spouse. But also, her life expectancy was longer than she actually lived. And so then there was an argument, well, maybe she was supposed to live something like another 8 years, but she only lived another 3.5. So
Mhm.
she only really lost him for 3.5. And what was the real loss? And so we actually had a pretty significant legal briefing other that really about the facts about the state of Indiana law on life expectancy of a surviving spouse, because there is some case law that says that recovery is not always best based upon how long that person lived, the spouse, but how long they should have lived. And we argued in our briefing that the spouse may have lived longer if her husband hadn't died prematurely.
And we actually went and we found some studies that supported our theory of that, and I found the author of it, and we got her to write us an affidavit that her data, was valid and it was used in all the things that help you get evidence, and now we didn't actually get it in, I don't think, at the end of the
No,
day.
but I mean, and we talked about, and this came in that we talked about not really the marriage did the marriage statistics come in that only like 1% of the
She would.
population.
I think he
So,
objected, and
he objected and she sustained it, but we did briefing afterwards, and the fact of the matter
you
is
made your point.
we made our point.
You made your
Yeah,
point.
yeah, that only like like less than 1% of marriages reach 61 years, and that's how long they had been married, and so that their bond was very special, and her reliance upon him as her spouse was very special, and the children who were, in their older 50s, the children talked about the importance of their parents' relationship and importance of family, and what their mother lost after their father passed away.
And what
Uh,
she went through, what she actually experienced without him, and how she changed after that.
and one of the big things we talked about as far as the sadness and loss that she experienced, we're not allowed in part three, we're not allowed to talk about liability or negligence because that is presumed at that stage. So you can't talk about any of the bad things that caused this, which is of course one of the driving factors of the value of the case is how egregious the treatment was. But one of the things we did emphasize in our trial, part three trial, was that the mother's sadness and grief over her husband passing was exacerbated by the fact that the death was so unexpected because nobody prepared them, because nobody was truthful about what was going on, and in part towards the end tried to kind of blame her for something wholly like
Mhm.
just fabricated,
Right.
but that her grief was just because she had no ability to prepare for her husband's passing, even for days before, because they knew for days that it was almost inevitable. That she found out mere hours before that when he went to the hospital, like, we're not only going to the hospital. Once he goes to the hospital, like, he's dying, and he's dying like now. And so that grief that she experienced was so, so strong. And so we were able to get some of the facts in on what kind of led to her profound grief afterwards. And in fact, just spending that time trying to figure out what actually happened led to significant grief too, because she put some blame on herself for
Oh
his
yeah.
passing, but it was completely unnecessary.
Right. Well, I think the story I remember being like that had like such an effect on me personally was that when someone's dying unexpectedly and you know that they are, the doctors ask you not to tell the person that's dying that they're dying. So you know, she's speaking to her husband in their last moments together,
She can't.
talking about the future because she doesn't want to tell him and scare him.
Yeah.
And it just like I can't even almost
Oh,
talk
yeah.
about
I
it
mean,
right
she
now.
can't have like a real goodbye
Yeah,
Right.
she
because
can't say
he'll
goodbye
have
at
like
all.
a freak out about
Yeah.
it.
Yeah.
And then I think, some of the family, they weren't even able to come back to say
S-
goodbye. Some of the children.
Yeah.
And they, they had prepared to bring him home, right? So one of the kids was in town in order to bring him home. The other ones
Sure.
were like getting ready to come back and take him home. And the daughter had kind of said, "Is he doing okay from the surgery?" And then she went away, was out of the country at the time. So she and one of the other siblings couldn't even get back in time before he passed. And like it was just this is how sudden this was, right? So it
Yeah.
wasn't it literally went from we're all coming to bring dad home to we're going to dad's funeral and half of us didn't even get to say goodbye or two-thirds of us didn't even
And I
say
think
goodbye.
even at the time of the funeral, they didn't really understand what had happened. It was their it was the not knowing what happened that led the family to even pursue the case because they just had more questions than answers.
Mhm.
Yeah.
And so then once they start pursuing, then they get the medical records, and then
They start finding out more.
They don't even realize it though until the case is with George's office. Like that's who tells them what really happened.
Mhm. Yeah. But thank goodness that they questioned it.
Right.
Because I think that there were a lot of things that were being thrown out as to what caused his death that were just things, health issues that just happen to older people.
Like like I think even they because his toxicity was so high, they were even suggesting that it might be leukemia. So this is the kind of thing that like right. I mean,
Yeah.
And I mean, unlikely. I don't think I certainly didn't do an autopsy. You're like, oh, okay. Well, I mean,
right.
my father died. We didn't know he had leukemia. Okay, but
Plus, he's 82.
Mhm.
yeah,
When you get to that age.
it just for them it was like everything was fine and then it wasn't fine.
Yeah.
And they just couldn't figure out how does somebody's health turn like that. I mean, a capable human being, how does their health completely turn with no explanation at all?
Yeah.
Particularly when the physicians who did the surgery are saying, "No, this is successful. He's actually responding well to rehab, but all these other things are happening and
Yeah.
he's having all these other symptoms that are completely unrelated to the reason he's there in the first place."
Yeah.
Mhm.
Wow. So, what was the result for the family?
So at the fund, because we were under this is 2016, so the max we could get from the doctor was 1.25. Is that right?
Yeah,
Yes,
yeah.
was 1.25 million. So when at the fund, the most we could get was 1 million for the family, and the verdict was 900,000.
So a win.
Yes.
Absolutely.
Yes.
Yeah, the fund asked for something very close to zero. I mean, they didn't ask for zero, but
I think we said something like 100
I think
maybe.
he said he asked for 100. So I mean, obviously,
And then, and I mean, that's a big verdict especially for someone that age, because I think statistically you get a lot of verdicts that are reduced because of people's age.
well,
Yes.
and I think that
Overall.
well, and that's what the fund felt like
Yeah.
because you have to also understand because that's in addition to the 250 we already gotten from
Yeah.
the carrier that got us there and the confidential settlement amount that we got from the other players. So that was just the additional, but that's ultimately what the fund argued is that
Mm.
he's older, she's older. Um, she only lived for 3.5 more years. How much is that loss really worth? And obviously the judge, because this is a part three is a judge trial, the judge felt that it was worth a substantial amount,
Yeah.
$900,000 more than what we had already recovered.
And I mean, imagine if he was unmarried with no dependent children, then that 250 was pretty much all you were going to get.
Oh well, yeah. I mean,
Yeah.
we would have. I mean, yeah, we.
I mean, we probably would have tried the case.
Well, the thing is that the 250, but then you would have gotten a much smaller settlement from the facility,
Right.
Yeah.
and
Of
that would have
course.
been and that would have been it.
Right.
The case would have been over. There had been no excess coverage to go to the fund because between those two defendants or the facility would have said, we're not paying anything. Go get your money from the fund.
Despite how bad this was. I mean, we called this like it was like a snowball.
Yeah.
Like just negligence upon
It's gross
negligence.
negligence.
Right.
The more you look, the more you saw.
That's crazy. You have to prove. It's almost like to meet the threshold on these med mal cases, you have to prove gross negligence or recklessness. You know,
Well,
not
technically you don't, but it does feel that way,
It
right?
feels that way. It feels that just negligence is
not
se-
enough.
it seems forgivable.
But you do have to prove gross negligence in a case that happened during COVID. That is
Yeah.
the law.
Yeah.
So, you know, and I think Katie and I are both of the same mindset that understaffing is gross negligence.
Yeah.
When you don't staff to like the sickness level of people, then that is it puts everyone in danger, including the people that are providing care in those places.
Which unfortunately leads to people quitting, which it leads to further understaffing issues.
Yeah. So this case, you guys were nominated for Trial Lawyer of the Year.
They were.
We were.
Congratulations. You didn't get it. There was a lot of
There was a lot,
strong competition.
very strong competition.
Yes.
But that it was a great experience for us to do that. We did it on Halloween.
We did.
It was funny. It was Halloween of 2023, and then the order came in last year, just actually almost right at a year ago. I think it was right before Valentine's Day of last year. I remember when the order came through. And a very well written order from the judge, because you get very detailed findings. I think it's like almost 20 pages.
Yeah, I mean, if you really want to know what we got on this case, you can just read her opinion. You can figure it out.
Yeah, it tells you all the details. It's some of the settlement's confidential, but it does come into play on these cases. But
Particularly when it's argued against you, right? So it became part of this just because that was the argument from, part 3 was that we did so well that we shouldn't get any more.
I think there was some legal maneuvering on the joint and several liability between the facility and the doctor. Also, I argued for the first time ever, captain of the ship, which is definitely not anything I have ever argued after law school or addressed or dealt with, but definitely got to argue captain that our qualified doctor who we were dealing with his negligence at the fund was the captain of the ship, and so he was clearly at least 50% at fault because he is the fail stop for the facilities. He's the only medical doctor. He is the one who signed the order. He is the one that is reviewing the medical chart and assessing the patient's symptoms, and he failed in every respect. So for anyone to argue that the remaining defendants had as much or more responsibility than him is not true, and so therefore any settlement we got from the other remaining defendants should be presumed to be less than 50% value.
But again, it's all so complicated, right? Like if you hear, like you're listening to this today, like as one of our clients, you're like, wait, what did they say? Right? I mean, that's the kind of argument we had to make to be able to get what we did for our family in this case.
And I think some of the things, I mean, obviously attorneys listening to this, they'll have an idea what we're talking about. For you, med mal, you're listening going, I feel you, I understand. If you're a client, I think the takeaway, a potential client or someone who's been harmed, the takeaway is that this is complicated, and we're doing our best, and we're doing our best for people like you, people similarly situated, and we wish we could help everybody, but we can't. And the reality is that if your case is accepted, is that everybody has to have some patience, because we're trying, and we will fight till the end, even if that end is in 5 to 8 years.
Yeah.
Mm-hmm. And I think too, just from a perspective of not necessarily about med mal, but as far as like working together, I think probably from the first time I met you, Katie, I always thought I want to like work with her. I want to try a case with her. Um, because I feel like we have this similar mindset when someone tells us a case is worth something that it isn't, we will show you that
Right.
it's
Proof.
worth what we think.
Yeah, then we put
And
baby in the corner.
exactly. And so I think that at least since I've known Katie in my career, I've always been pushed by her to do better, get better results for clients, and um to really think about what something is worth and how to go get it. And I'm just very grateful for her, and I'm grateful for this experience that we had together. And
Oh yeah, we really enjoyed it, and I'm glad to push her. She pushes me too because we both feel very strongly about representation and value and working hard and pushing cases. We have very different styles in how we pursue our cases and how we show value, which is great because we're advocates and not one is better than the other. And working on this case together, we were each able to highlight our strengths and our talents on our advocacy. Because as we all know, with trial lawyers, not one style fits all.
Right.
And we have different styles, which is completely fine. We have each had success with our styles. And in this case, I think that it worked out really well that we were able to and not just for the trial, just the whole pursuit of the case in the 2.5 years that we worked on the case together. I think it was that long. It felt that long. Maybe it was a year and a half. But I think that the pursuit of the case, we divided up the work based upon our strengths on handling the cases.
Yeah.
I think in this industry, it can, especially in med mal, it can be really easy to just feel pretty depressed about like the hand you've been dealt. But I've always like tried to take a step back, and especially when I'm around people like Katie, and like and find the areas where we can have fun and where we can be creative and take new chances and discover a new area of law or a way to argue a case.
Yeah.
And I think this gave us all of those things in one.
Yeah.
We were able to try some new things and be creative and get to experience each other's styles and put them together. It was very, very fun.
Definitely did some creative negotiations into some of the other parts. But yeah, I mean, on these nursing home cases, I mean, the reality is they are tough, and I always say, if not us, who?
Mm-hmm.
Right.
Who would do it?
Right. Exactly.
It's a lot of work, but if we don't do it, then there's no accountability.
And y'all, we're going to
Yep.
all end up there one day.
Yeah, we are.
And so if we don't try to get them, I mean, and it's only going to get worse right now. And the more and more private equity is getting into nursing homes right now. Like Neuropsych Hospital just got by private equity, and it was bad before. I don't think it's going to get better now when the literal incentive is money.
Yeah.
Mm-hmm.
So these are all things that are going to affect every single one of us. So, we all need to be active in making sure these places.
Yeah.
Well, if it's not affecting you right now, it's going to be your parent or your
sibling, or I
Yes,
mean, God
somebody
forbid,
in your
eventually your children if you're long gone. I mean,
Right.
you just never know. I mean, everyone has a loved one on some area of their life that is in nursing care or has been or will be. It's a fact.
Mhm.
And that doesn't mean your family puts you in a nursing home. This could just be, I have a surgery, and the only place that, yes, it's rehab, like exactly like in this case.
Yeah.
He was supposed to be there for a couple weeks.
Yeah, I have several cases now of neglect in rehab that was not intended to be end of life or long term. It's people who were there for a short amount of time, and I mean, sometimes they're there for a couple days and they've had malpractice on them, and the family's just expecting them to come home soon, and then they don't come home.
Yeah. So, well, thank you guys. Thank you so much.
Thanks for having
I
us.
appreciate it. It was a great conversation.
Thank you.
Thanks everyone for listening to Circle City Conversations. Be sure to subscribe so you don't miss out on more future conversations.